So you want to break up with your business partner and you don't have a shareholders agreement or an operating agreement, and the bylaws or the articles of organization are silent on this particular issue. What do? Every state has its own set of laws and rules that deal with corporations, limited liability companies, and pretty much any entity form that's recognized in that state. You should absolutely be looking at all of those documents. So did you look at your bylaws if it's a corporation? Did you look at your articles of organization if it's a limited liability company? If those are silent as to termination, disassociation, or dissolution processes, which are all the things that you would use to split or move on from your current partners, look to the state statutes because they have the default rules on how these things are handled. Now, there's nothing that prevents you generally, unless a state does, and you should consult an attorney in your state on this issue, but there may be nothing that prevents you from starting a business, right? Another business, and just stop giving your efforts to this business. Just because you're an employee of a business and an owner of a business doesn't mean that you have to continue being an employee, just like anything else, right? You're not bound by anything unless there's a contractual obligation to the contrary. But if you're looking to start a competing business, want to split from your partner, want to do something else that's in the competitive space, look to your state statutes. However, and this is really important, unlike a state where there's divorces for irreconcilable differences, once you're in a business relationship, it may be the case that you can't start a competing business. You may have fiduciary obligations, you may have statutory obligations that are set, and so you may be stuck. There's a lot of different ways to go about the process through disassociation or dissolution, but none of those may be availing to you, and you may be stuck, but there's probably 7 or 8 different things that you can all look at, including the bylaws, the articles of organization, shareholder agreement or operating agreement. If you don't have those, look to the state statutes. If not, look to the common law. There's obligations of what you can and can't do, and there's things that you may want to do that you absolutely can do. And then there's things that you may want to do, but you can't do, and even then there may be exceptions to that rule. You really need an attorney to walk you through this process because now you've entered into the land of substantial complexity in the commercial process, in the business dispute process. And I've been involved in a ton of cases where this has happened, and we've been able to either negotiate and settle a resolution, force a buyout, or implicate some other process through the law in order to get our clients what they're looking for. If you have any questions with regard to this or want any other answers to any other questions, my name's Michael Smikin. I'm here at Callagy Law to answer whatever you need.